Children and Society and referred the case to the court to the case of the Derrick versus Director of Public Prosecutions, WLD, which stated that the purpose of legislation is to curb child pornography, which is seen as an evil in all democratic societies. The affidavit also deals with the offense of money laundering, which stated it is also extremely prevalent in the court's jurisdiction, where it attracts a minimum sentence of 15 years imprisonment per count. There were also investigations in terms of Section 205 of the Criminal Procedure Act. It was supplied to First National Bank, which revealed the transactional activity of applicant 1 and a monthly turnover credits received into his account. There were several amounts that were received into his account. The state alleged that there was no fixed income received into the account. It was evident from the above turnover that the amount of 2,538,095 rand and 10 cents was received in total. According to the warrant officer, the applicant is facing a minimum of 24 counts of money laundering, which carries a minimum sentence of 15 years per count. The affidavit also states that between the period of September 2024 and January 2025, the FNB Premier account received a total of 778,609 rand and 21 cents. The sources of income in respect of the total amounts was summarized as follows. For the period of September 24 and January to January 25, the amount received was 573,964 rand and 56 cents, which, according to the officer, is derived from an unknown sources, possibly cryptocurrency. For the period between September 2024 and January 2025, the FNB also received an amount of 204,644 rand and 65 cents from various sources, which needed to be confirmed. For the period September 24 to January 25, applicant 1 made e-wallet payments to the total of 37,800 rand on a weekly basis to a cell number that was listed. Between 30th December 2024 and January 2025, applicant 1 and 2 visited Phuket, Thailand, and incurred expenses in the total amount of 130,000 rand, 842 rand and 10 cents. Applicant 1 also had further accounts as and referred to ABSA, Bidvest, Luno, Capitec, Discovery, and Netbank. There are still investigations continuing. 39 virtual cards were linked to the FNB account. The 39, although the applicant explained in his replying affidavit that these virtual cards linked to his account is nothing more than cards that were used for online purchases, he did not state what type or kind of purchases these were. He stated that it was standard practice to obtain a virtual card for online transactions to safeguard the details of the credit card, and the practice is encouraged by the banks to prevent data theft and cloning of cards. The card would lapse after a purchase and be replaced with a new one, and this is not something mysterious or unlawful. Applicant 1 also explained the statement, which was stated that he will continue with his business as he had, and it should not be placed in a context that creates an impression that he will continue with unlawful actions if released on bail. He does not dispute that the charges are serious, but submits the allegations do not support the principle argued by the investigating officer. He also stated regarding the sentences that prosecutions and sentences that there are no reported cases where a person under similar circumstances like himself were charged with contravening the provisions of the Prevention of Organized Crime Act, and believes that the charges relating to money laundering were only included to elevate this application to fall within the ambit of Schedule 5. It is contrived that the applicants have to discharge the onus to show that the release on bail is in the interest of justice. In paragraph 20 of the replying affidavit, the applicant 1 stated that the investigating officer gave a vague description of a monthly turnover credit without referring to where this was as a result of payments between his accounts as stated in his initial affidavit. The court finds this to be far from vague. There is a transactional history of the income received in the account, and he stated, and the state provides this transactional history of income to show that it is improbable that he earned 50,000 rand per month. In applicant one's first affidavit, where he stated he earned about 50,000 rand per month, yet in his replying affidavit, he went on to explain that he earned 50,000 rand a month after his expenses were paid, after the state's opposing affidavit was read into the record regarding the funds that were paid into his account. In his original affidavit, he stated, and the court quotes, "From these online trading sites, I earned approximately 50,000 rand per month," not mentioning any of the expenses. He disputed that he earned the amounts indicated in the tables, but stated in paragraph 21 of his affidavit, I quote, "All was received into the bank accounts held by myself and applicant 2. It is clear to the court that applicant 2 also received money into her bank account. Applicant 1 submitted that if given access to the records and bank accounts, he would be able to justify all these transactions when ventilated during the trial. He also stated that 24 counts of money laundering and 15 years per count is nothing more than generalization, and the sentences as well as the fines are not realistic. He stated that the amount of 189,500 rand was transferred to the second applicant, and this was done on the day of his arrest when the police seized his phone and his electronic equipment. The second applicant had no other source of income and not the impression created to transfer money in order to conceal or mislead the court. The burden of demonstrating that the disputed funds came from the online trading business that purported to be running was not met by the applicant. In spite of his assertions, he failed to present enough proof to the court, such as detailed financial records, transaction histories, or corroborating documents to clearly connect the money to his purported source of income. Consequently, the origin of the monies cannot be verified, and his claim is not supported by enough evidence to be accepted, bearing in mind that the undercover agent had made 3 purchases for child pornography. Applicant 1 stated in his replying affidavit that the investigating officer has speculated on the crypto accounts which they do not have access to. And he stated it is nothing more than speculation, and the only amount of 8,000 rand is available in this account. Despite this, the applicant failed to provide any credible evidence to refute these assertions. He did not submit transaction records, trading statements, and in the absence of proof, the officer's speculation then remains undisputed, casting doubts about the veracity of the applicant's claimed revenue sources. In respect of applicant 2, there's a summary of a transactional activity. Applicant 2 holds accounts with the following financial institutions, being FNB, ABSA, Discovery, and Nedbank. These accounts are under investigation. The annual credit turnover for 2023 was 420,955 rand and 52 cents. The annual credit turnover for 2024 was 1,254,029 rand and 58 cents. And according to the state, this is a 198% increase from 2023. The monthly turnover in the FNB account for the period February 2023 to January 2025 fluctuates. These are amounts that reflected in the table for the period 2024 up until December. The main sources of income in the account are D. Wilkins account, Moodley's credit card, SnapScan, and Zapper payments. Once several SnapScan and Zapper payments were received, applicant 2 transfers the funds to applicant 1's account. In addition, during June 2024, several payments were received into applicant 2's check account with description Tiona Megan Moodley, even though the state said that the account from which the payment made was not linked to applicant 2. After receiving the payment, applicant 2 would transfer the funds into applicant 1's account. Moodley's account and credit card were used to pay for several online purchases. The eVox, virtual matching in cloud-to-run applications, Cloudflare type of firewall, security protection for cloud services and website, Web.io and AI platform to build, host, and scale websites, Plesk, Webs Ops Posting, Atlac, Technology Domain Registration Service, Paystack. Paystack helps business in South Africa get paid by anyone, anywhere in the world. Hostinger, a website builder and hosting. Paddlenet, payment infrastructure that helps software companies manage payments, subscriptions, and taxes. Google One, subscription services that provides additional storage space for Google Drive, Gmail, and Google Photos. Moodley's credit card was used for 7 payments to Google G Suite with reference Dank Mega between July 2024 and November 2024. From 19th March 2024 to 17th May 2024, a trend was noticed that after credit cards were received into applicants' 2 FNB Premier account via Zapper Netcash, where Zapper is a mobile payment app using Netcash payment gateway, a rounded off amount would be transferred to Wilkins' Discovery account. From the 23rd of May 2024 to August 2024, a similar trend was noticed that after several credits were received into applicants' 2's FNB account via SnapScan, a contactless payment app for online payments, a rounded off amount would again be transferred to Wilkins' FNB account. According to Credit Bureau, Moodley is the sole director of Skills Up Click Pty Limited. Skills Up holds a FNB Gold business account that was opened in February 2024 and closed in September 2024. The income in that account is derived from applicants' 2 check account. The funds are then transferred out of Skills Up account to applicant 2's Discovery account with the descriptions Skills Up Live. The applicant has approximately 34 virtual cards linked to an FNB account. 2 of these cards are named Dank Megas. The metadata files shows that Tiona Moodley as both the creator of the file as well as when it was last modified. The Excel file contained the names of listed pornography packages that can be bought. To include pricing packages were named banned TikToks, rape, pedo mom, etc. And there was a screenshot of the packages that were for sale. There were also WhatsApp messages contained on the laptop used by Moodley, applicant 2, which includes conversations between herself and applicant 1. These conversations include exchange of specific identifiers like crypto wallets, passwords for the website, named Dank Megas, and there were screenshots attached to the affidavit. Applicant 1 stated in his replying affidavit that all was received into the bank accounts held by himself and applicant 2, where the court interprets it to mean money received. The court finds that there is prevalence of this particular type of offense, and I do find that there is a likelihood that the applicants will endanger the public safety or a particular person, as evidence from the past conduct of being in possession of pornographic material which was made available and sold to the public. In dealing with Section 64B, where there is a likelihood that the accused, if he or she were released on bail, would attempt to evade the trial, the warrant officer stated that the applicants are facing a minimum period of 5 years imprisonment for each image of each video depicting child abuse images in their possession. It is noted that more than 10 million images and videos had been counted so far, so there will be a long term of incarceration, and therefore it's an incentive to evade trial. Also, the applicant's financial resources to evade trial is evident from the fact that there was 647,303 rand cash that was found in the premises, and that excludes funds in the bank cards. The applicant also uses cryptocurrency, Luna and Bitcoin accounts, to which they currently do not have access. The state has a very strong case against the applicants, and the bail conditions are not always enforceable. Applicant 1 stated in reply that the allegation that 3 countries also made inquiry for his extradition, there is no indication that his release will jeopardize the proper functioning of the criminal justice system, and that somebody may request for an extradition is grasping at straws. The court notes that inquiries about his extradition are likely to result in the applicants fleeing to countries without extradition treaties with South Africa or other requesting jurisdictions in order to avoid trial. There is still a high chance of absconding because international travel is easy. The applicants might take advantage of legal loopholes to evade prosecution if prompt and efficient legal action is not taken to stop their evasion, which would thwart the justice and jeopardize the extradition procedure. In the replying affidavit of applicant 2, she stated that she denied all the allegations against her, and she was effectively only the administrator of the business. The first accused was a person in control of the business, including the accounts. The first accused had control of her personal accounts and would either use them for his own or the business purposes. Alternatively, would instruct her to make payments on his behalf or on that of the business. As she stated, from the bank accounts, as can be seen from the bank accounts, she did not receive large amounts of money for her own benefit and personal use. She did not participate in any distribution of the funds. She had no idea as to whom or for what purposes the e-wallet payments were made by accused 1 to any cell phone number. She stated that the first accused would ask her to create websites, including the front page. She also stated she did not intentionally or for any wrongful or deceitful purpose destroy any evidence. She was well aware the state confiscated various devices and images, and other information was captured. She stated the first accused was also the controller of Skills Up Click and controlled all the cards related thereto. Furthermore, as can be seen from the opposing affidavit, there was no interaction with the users of various sites, and it was the first accused who introduced themselves to the users thereof as Gavin Walker. She said she had no funds in the crypto wallet and she did not live a lavish lifestyle. Effectively, she was only an employee and a puppet of the first accused. She said she is not a master of any criminal activity nor a party to any sextortion matter, and no allegations were made against her with regards thereto. She said the word mega is commonly used. Words indicate a website is substantial, that it is substantial. She's not a flight risk, and it was the first accused who had all the contacts and was the person running the business. The court finds applicant 2 made these assertions that she was only the administrator acting under the applicant 1's directions and that she had no knowledge of the business, despite her not mentioning this in her earlier statement. It is clear now she's trying to convey that her function was restricted to administrative tasks. She notably added this explanation only after the state's affidavit was read into the record, which calls into question the veracity of her statements. She also makes an effort to disassociate herself from applicant 1, and in her answering affidavit, which seems more like a calculated move to downplay her role than an accurate assessment of circumstances referring to the applicant 1, as she refers to him as a misogynist, even though they were in a relationship for approximately 2 years and 7 months. Applicant 1 stated in his replying affidavit that the network of people the investigating officer believes would support him is nothing but speculation, unsupported by any factual basis. The essence of the bail application is not the strength of the state case, but whether he will stand or interfere with witnesses or evidentiary material. He submitted that there is no factual basis to find, beyond speculating the possibilities that there is a likelihood he will evade or interfere with the case or witnesses. The court disagrees. Section 66H of the Criminal Procedure Act directs that a court may consider the nature and gravity of the punishment likely to be imposed. Furthermore, while an accused person such has a right to remain silent, the election to do so has consequences. When the presumption of innocence is considered within the context of a challenge to the merits of the state's case within a bail application, the accused would have to show in a balance of probabilities that he or she will be acquitted of the charge. It was argued on behalf of applicant 2, there was not a single allegation that pointed to her. In her replying affidavit, she stated she logged out of Gmail accounts that were not hers, proceeded to delete emails from megalinks that were sent to her by either megalinks or the accused. She also deleted WhatsApp messages containing megalinks and some correspondence sent by applicant 1 to himself on her phone, and she stated that the applicant would use her phone and other electronic devices. The court finds that it is incredibly unlikely and nonsensical applicant 2's claim that the first applicant utilized her phone and other electronic equipment to transmit messages to himself. It seems odd that the first applicant would utilize her gadgets for this purpose, which calls into question the veracity of her allegation. Her quick assertion seems to be an attempt to dissociate herself from the applicant's commercial dealings. Her claim also casts doubt on the veracity of her account of events by implying a determined attempt to distance herself from any possible wrongdoing. Her stated disassociation is not supported by her failure to explain WhatsApp communications which she exchanged with the first applicant, nor does it exonerate her. The lack of convincing and unambiguous response casts suspicion on her efforts to dissociate herself from the first applicant's commercial endeavors. Instead of overlooking the problem, she would have offered a plausible explanation for the messages if she had not been involved. This is crucial. This is a crucial element, and it also raises the possibility that she was aware and involved of the issues that were being investigated. I find that the state has a relatively strong case against both applicant 1 and 2, in spite of applicant stating applicant 2 stating that she was only the administrator. This may have given her give both of them an incentive to evade the trial or extraditions, as the porn content was made available to both the international community, both the local and international community, for sale, and sentences imposed are likely to be long terms of incarceration, even though it may not be what the state has suggested. In dealing with 64C, where there's a likelihood that the applicants, if he or she were released on bail, will attempt to influence, intimidate witnesses, conceal or destroy evidence. The warrant officer stated that the applicants are either self-trained IT specialists or received training, as the applicants made a huge amount of money from child abuse images, and therefore it is in the best interest to have it stored in alternative storages or in cloud accounts which have not been discovered. They are also able to destroy or conceal any evidence that they have not confiscated. They simply need a device that is able to link them to the internet to destroy what is still being investigated. Applicant 1 stated that he will not destroy any evidence and that the submission was absurd. Applicant 2 stated she logged out of her accounts as it was not hers. She deleted the emails from Megalinks that was sent to her either by Megalinks or accused number 1. She deleted the WhatsApp messages containing Megalinks and some correspondence sent by the applicant to himself on her using her phone. As she stated, the applicant would use a phone and other electronic devices. She did not, for any unlawful purposes, destroy any evidence, and the state returned her cell phone on the day of her arrest. It was therefore made no sense that the state alleges she attempted to unlawfully delete any material. The warrant officer stated that in his opposing affidavit in paragraph 30 that the applicants have a network of people able and willing to assist them in evading arrest in order to avoid prosecution themselves. These type of offenses are extremely difficult to investigate and before the court, and resources are limited. The court notes that it's impossible to completely rule out the potential of evidence being erased due to the increasing sophistication of cybercrime and other cyber activity. With the use of sophisticated technology, digital transactions can be altered, erased, or concealed, making it difficult to determine their actual origins. It may become more difficult to prove the validity of financial transactions and the veracity of claims if important evidence is destroyed due to a lack of adequate safeguards and timely verification. I find that there is a likelihood that the applicants will attempt to conceal or destroy evidence, and it must be taken into account the ease at which the evidentiary material could be concealed or destroyed due to the nature of cybercrime itself. Under 64D, where there's a likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system, the South African police received information that there was no less than 3 countries that made inquiries for possible extraditions of the applicants. I've dealt with this. Applicant 2 denied any involvement in the business of applicant 1 and stated he controlled her accounts and her electronic devices. And the inference that can be drawn from such actions is perhaps this was done in order for her not to be implicated in the commission of the offense of the crime in question, knowing that she would probably be refused bail if she associated herself with the applicant 1. And I refer the court to the case of State versus Jacobs versus the State, 2004 for SA. These provisions in respect of the subsection mainly concerned with the behavior of the applicant before the present bail application. The bona fides at the time of the arrest and immediately after may play a decisive role in the determination of the release of the applicant. The basic rule is to provide the information to the court about the previous convictions, outstanding cases, in terms of sections 11B, and the court. And they will provide details including addresses. The court finds that they had provided this information and addresses were verified. The court will deal with 64E, the likelihood that the release of the accused will disturb public peace, will disturb public order or undermine the public peace or security. The warrant officer stated there has been an outcry from the community to release the applicant, applicant 1 to the custody of the community to be dealt with by them. Applicant 1 argued that the state relied on the outrage of the community to oppose bail and that the reliance is misplaced, referring to case law. It is important to note that the subsection 4E expressly postulates that it has come into play only in exceptional circumstances, and this unusual category of factors is to be taken into account only in those rare cases where it is really justified. At the time of the investigation by the FBI, the website was in the total size of 396.64 gigabytes that contained 1,136 folders and 146,938 files, all containing explicit images of child sexual abuse material. The perpetrator introduced himself as Gavin Wilkin. At the time of the arrest, the images retrieved exceeded 39 terabytes. The stock of the applicants increased substantially since the investigations. The securitized identity records of the perpetrator on Google records linking the watermark on the email used by them to dankmegas@gmail.com, dazwilkin@gmail.com. This was also linked to the email address of the business in South Africa, admin@pinnacleproperty.co.za. The affidavit also of the warrant officer said that it is noteworthy that applicant's one mother is the director at Pinnacle Property, but the company was liquidated in 2024. The warrant officer stated that there are more than 10 million images and videos that had been counted so far. The court notes that had it not been for the assistance of the U.S. law enforcement agencies, including the FBI Washington, the U.S. Embassy Cyber Task Force, and other international partners, the local authorities would likely have remained unaware of the criminal activities in question. Their expertise and advanced cybercrime detection capabilities played an essential role in uncovering illicit transactions. Furthermore, there has been a significant outcry from the international community regarding the purchase and distribution of child pornography, prompting increased cooperation between global law enforcement agencies to combat such heinous crimes. The collaboration underscores the seriousness of these offenses and the necessity of cross-border efforts to bring perpetrators to justice. The warrant officer also said that the applicants hide behind a screen and is able to do so effectively anywhere in the world. They are the unseen predators. Had it not been for the assistance of the USA collaboration with the SAPS, the applicants would have remained unseen predators for a very long time and were conducting a thriving business of the sale of child abuse material and living a lavish lifestyle. The court finds that the nature of the offenses and the circumstances under which the offenses were committed is likely to induce a sense of shock or outrage in the community where the offense was committed. but not only locally but also internationally. The court finds that the sense of peace and security among members of the public, both local and international, will be undermined and jeopardize the public confidence in the criminal justice system, including internationally. The court also notes that the applicants did not challenge the state's evidence insofar as the images received from the devices and did not provide proof of income received from their businesses in rebuttal of what the state alleged the income to be. They made statements that the case is based on speculation, and this, in my opinion, stands on precarious grounds. The applicants raised the difficulty with prosecutions and convictions of Section 5 and Section 6 of POCA, which is the proceeds of organized crime, and the offenses of child pornography. In my view, this is a matter which the trial court would be better placed to adjudicate. It is not an issue that this court is called upon to pronounce, lest it be the applicants making provisional findings of his guilt or innocence. I am of the view that the applicants failed to discharge the onus placed on them to show in a balance of probabilities that circumstances exist which, in the interest of justice, warrants them both for their release and bail. Applicant 1 and 2, please stand up. Your bail is accordingly denied. You remain in custody. Thank you. Sorry, I haven't excused him. I just said bail is denied. They remain in custody. I need to postpone your matter, so please come forward. Yes, State.
This time will be suggesting the date of the 8th of April for further investigations. If my colleagues might have a look at their diaries.
Counsel and Ms. Simpson.
Please, Your Worship, the accused are in custody, Your Worship. To postpone the matter now basically for 2 months is not in the interest of justice. To take it beyond the purview of the court for 2 months for no valid reason by my learned colleague, Your Worship. I suggest approximately a month. That would be indeed sufficient time in order to do investigation, or at least be in a position to tell the court what the investigation is. And I suggest the 20th of March, which is just more than a month, Your Worship.
Yes, State, I'll agree with counsel. Can we perhaps do it a month, and then you can perhaps update the court as to her?
The situation is that I'm busy with a matter in the High Court until the end of March. That is one of the reasons why I request the very beginning of April. The 20th of March, it's not suitable. If we may then rather look at the 24th or the week of the 24th of March.
Will that be suitable?
24th would be suitable.
Thank you. The 24th is suitable.
Thank you. All right. Accused 1 and 2, you may suspend to the 24th of March back to this court. It is for further investigations. Bail has been refused. You both remain in custody. You are now excused. Can we take a short adjournment? I will send this notice. All right. Thank you. Thank you.